Welcome and thank you to today's webinar, Wills and Trusts, highlighting the facts, dispelling the myths. I'm Dana Nelson, Portfolio Manager here at Bell Investment Advisors. And with me, I'm honored and proud to have a professional associate of ours, Mark L. Cederborg, who's a trust and probate attorney and a partner at Cederborg and Bret, LLP. His firm, Cederborg and Bret, is located in Walnut Creek, where they specialize in estate work and taxation. Mark has been practicing since 1979 and in the Bay Area since 1981. He specializes in estate planning, trust, and probate administration. So again, we're honored and pleased to have him here today as our guest speaker. Before we formally begin, I'd like to just cover a few housekeeping notes. We will allow time at the end of today's presentation for some Q&A. You can submit questions throughout today's presentation in the upper right-hand corner of the control box. If we don't address your specific question, feel free to contact us directly and/or we can get back to you if your question is not answered. And finally, if you're having any audio or technical difficulties, there's two remedies. One, you can hang up and redial or re-click the link, or you can call our offices at 800-700-0089. Today we'll be covering a variety of topics, and many of these topics you can really dig down deep on. So it's really going to be many high-level aspects that Mark will walk us through. The specific areas we'll talk about will be intestate succession, some specifics around wills and trusts, or wills versus trusts. We'll talk about probate, specifically living trusts, and then some additional considerations followed by some questions that we'll aim to answer. So as an investment advisor, we often hear clients with sometimes misconceptions. So the first one is, California will take my estate if I don't have an estate plan. Mark, maybe you can talk to us about that.
There's actually some truth to that. There is a provision in the probate code that provides that if someone does not have an estate plan, or if intestate succession does not apply to them, their estate will what's called the escheat to the state of California. Now, the California State Legislature has passed Probate Code Section 6400, and there's several sections to it. This is called the intestate succession statute. This applies to both community property and separate property of a decedent. And essentially, the state of California has written a will for you. So it's very seldom that an estate is actually going to escheat, because this provides for a schematic of where your estate would go if you have any living relatives at all. It would be only in the very remote situation where an air searcher would be unable to find any relative, any blood relative, that the estate would actually go to the state of California. I've never seen it happen. But the intestate succession statute leaves some things to be desired. If you haven't designated what you want to have happen by setting up an estate plan, then your estate is going to be distributed per this code section. It may end up with people that relatives you don't care for, that you never would have intended to benefit from your estate. They may end up with a portion of it or even all of it. And I've seen some situations where someone ends up with the estate who really didn't even know the decedent, and certainly the decedent didn't know them. So the important thing is to put something in place. In any situation, though, under intestacy, you're always going to end up in probate to get that estate distributed.
Great, thanks, Mark. Now, another myth we hear from time to time, and perhaps you can dispel this or at least discuss it, and that is probate is always expensive and time-consuming.
I hear that a lot, and we certainly see that in a lot of the advertisements for some of these trust mills that are trying to sell trusts to everyone. And a good lawyer response to it is, it depends. Probate, in a nutshell, is a process. It's a term, first of all, that's used quite often, and not everyone really understands what it is. But it's the court process of administering an estate. It requires the person who's a nominated executor in the will to file a petition for probate. If there is no will, another interested party can file that petition. But they are petitioning the court to be appointed as the personal representative of that estate, to handle the estate, to collect the assets, prepare an inventory of those assets, pay any bills, taxes that are due from the decedent, prepare a final petition to the court reporting everything they've done, and then asking for permission from the court to distribute the estate. The expense issue involved with probate that we often hear about, I've heard people give the opinion that I don't want probate because the lawyers take 10% or more of the estate. I wish it were that high. It's not. It's not anywhere near that. The fees are controlled by the court. There's a statutory fee. The fees are tied to the value of the estate, and it is strictly controlled by that statute, and even that is subject to verification and control by the court so that fees are always kept somewhat reasonable. Then the estate ultimately is going to be distributed to beneficiaries only once that petition for final distribution is heard and the court issues the order for final distribution. In some situations, particularly with some trusts or situations where they haven't planned an estate well, probate can get out of hand, or the process of administering the estate can get out of hand, and people will start doing whatever they want. Probate adds a control mechanism. That person who's appointed as the personal representative has to answer to that court. They have to come sometimes and stand right in front of that judge and explain what they've done. And that provides a good control mechanism that gives an order to the estate probate process. The other complaint I've heard about probate is that it takes a long time. Probate has to stay open by law a minimum of 4 months. That's a creditor's claim period, so that any creditors can make a claim against the estate during that 4-month period. If they don't make their claim, they can be excluded from being compensated later. In reality, you have to file the petition, get a hearing date, so there's a month or two before that 4-month period starts to run. Once the 4 months runs, you have to file your petition for final distribution. That can add another, again, for the hearing time, or the notice for the hearing can be another 30 days, 45 days. So in reality, the shortest time you're really going to have to distribute an estate or probate an estate is going to be approximately 7 or 8 months. It's not the probate process that really delays this. It's the underlying issues. If you've got difficult assets, sometimes you have some problems like even identifying assets. Certainly some assets have to be sold, and in some of the markets we're involved in now with real estate, it may take a while to sell real property. You at times then in addition get feuding beneficiaries, feuding family members. These are the issues that come up, and it's those issues that delay the probate process. And I might add, those also would delay the trust administration.
Great. That's really helpful, because we often do hear about, probate being just a big pain in the rear, when the reality is it sounds like it's sometimes the underlying issues more than the process itself. And that leads quite nicely into myth number 3, and that is something we hear often, particularly living in California, and that is everyone must have a living trust.
Well, let's define what a trust is, first of all. And they come in various sizes and shapes, but we're talking now just about a living trust. That means that it's an active entity that someone establishes. They, by terminology, are the trustor. They set up the trust. They sometimes are called settlors. They make themselves the trustee, giving themselves the responsibility of managing those assets, and they're responsible to manage those assets for the benefit of the beneficiaries, who in the typical situation are also themselves. So in one sense, they wear three hats: the trustor, trustee, and beneficiary. The typical situation with a husband and wife setting that up, there's language often in trusts about beneficiaries requesting distributions from the trust. In reality, when it's the husband and wife who are the trustors and set it up, they just go about their lives collecting the same income they've collected, pay the same bills they've paid, file the same income taxes returns that they have always filed, and so nothing really changes. It's somewhat seamless. Once the trust document is established and signed, the trust itself has to be funded. A trust without any assets is a nullity. So assets have to be transferred into that trust. The most typical situation would be transferring the family home or real property into it. And that would require a trustor signing deeds from themselves to themselves as trustees of their trusts.